Start. Heard Shri T.A. Khan, Learned Counsel for the petitioner, Learned Standing Counsel appearing for the state respondents, Shri Ram Raj along with Shri Shujauddin, Learned Counsel for the respondent numbers 3, 4 and 5, and Shri A.K. Srivastav, Learned Counsel for the Gaon Sabha, Para. By means of the present writ petition, the petitioner has prayed for issuing a writ of certiorari, quashing the order dated 13.9.2013 passed by the Sub-Divisional Officer Amroha on the restoration application filed in suit number 153 of 2009 in bracket Srimati Samar Jahan versus Shamshad Ahmad Khan bracket out and others under section 176 of the UP Zamindari Abolition and Land Reforms Act 1915 bracket hereinafter referred to as the Act bracket out, as well as the order dated 10.2.2015 passed by the Additional Commissioner in bracket Administration bracket out Moradabad Division Moradabad in revision number 39 of 2013 to 2014 in bracket Srimati Samar Jahan versus Avez Naseem and others bracket out para. Wide order dated 13.9.2013, the restoration application filed by respondent numbers 3, 4 and 5 was allowed and the preliminary decree dated 24.6.2009 as well as final decree dated 10.8.2009 were set aside, whereas wide order dated 10.2.2015, the revision filed by the petitioner against order dated 13.9.2013 has been dismissed. Para. The facts giving rise to the present writ petition are that the petitioner had filed suit number 157 of 2009 under section 176 of the Act before the Sub-Divisional Officer Amroha without impleading respondent numbers 3, 4 and 5. In the aforesaid suit, a preliminary decree was passed on 24.6.2009 and thereafter final decree was prepared on 10.8.2009 para. The respondent numbers 3, 4 and 5 happened to be the sons of late Naseem Ahmad. Late Naseem Ahmad had 2 wives. From first wife there are 3 sons and from the second wife there are 4 sons. The petitioner herein claims herself to be the second wife of late Naseem Ahmad and on the basis of the registered will has filed partition suit impleading other co-sharers excluding the respondent numbers 3, 4 and 5. In the suit, a preliminary decree was passed on 24.6.2009 and thereafter final decree was prepared on 10.8.2009 para. Prior to the filing of the suit, the petitioner had filed an application under section 34 of the UP Land Revenue Act 1901 before the Tehsildar for mutating her name over the land belonging to late Naseem Ahmad on the basis of the registered will. The name of the petitioner was mutated in the revenue record by the Tehsildar wide order dated 29.4.2009. Seeking recall of this order, the respondent numbers 3, 4 and 5 who claim to be sons and heirs of late Naseem Ahmad have filed an application on the ground that on the basis of the collusive will mutation order was obtained without any notice or proclamation as required under the relevant statute. The recall application was allowed on 31.3.2012. The mutation case proceeded and ultimately the application filed by the petitioner was rejected wide order dated 2.5.2014. Para. Aggrieved petitioner had filed an appeal against the order dated 2.5.2014 that was dismissed by the sub-divisional officer Amroha. The petitioner has filed revision against the appellate order that too has been dismissed para. It is after recording her name in the revenue record on the basis of the order passed in mutation proceeding. The petitioner filed suit number 157 of 2009 under section 176 of the Act before the sub-divisional officer Amroha without impleading respondent numbers 3, 4 and 5 as defendants who are sons of late Naseem Ahmed. In the aforesaid suit, a preliminary decree was passed on 24.6.2009 and thereafter final decree was prepared on 10.8.2009. Against this, the respondent numbers 3, 4 and 5 have filed an application seeking recall of the orders which was allowed wide order dated 13.9.2013. The revision filed by the petitioner against order dated 13.9.2013 has been dismissed. Para. Shri T.A. Khan, learned counsel who appears for the petitioner, submits that since the respondent numbers 3, 4 and 5 were not parties in the suit, therefore, the recall application on their behalf was not maintainable and it was liable to be rejected. In his submission, at most, they could take this ground in appeal. In support of his submissions, Shri Khan has placed reliance upon the judgment of the apex court in bracket Ram Prakash Agarwal and another versus Gopi Krishnan in bracket capital D and others 2013 in bracket 98 bracket out ALR 269, wherein the legal issues involved have been summarized as under para. First, an application under order 9 rule 13 CPC cannot be filed by a person who was not initially a party to the proceedings. Para. Second, inherent powers under section 151 CPC can be exercised by the court to redress only such a grievance for which no remedy is provided for under the CPC. Para. Third, in the event that an order has been obtained from the court by playing fraud upon it, it is always open to the court to recall the said order on the application of the person aggrieved, and such power can also be exercised by the appellate court. Full stop. Over.